Tejas Motel, LLC versus City of Mesquite. Mr. Bobbitt.
May it please the court. My name is Milo Bobbitt, and I represent the plaintiff and appellant, Tejas Motel, in the case at bar. Now, this appeal involves a narrow issue that turns on the application of two recent opinions by two high courts and how that affects the application of res judicata under Texas law. I would like to spend my time today discussing that issue, the primary issue on appeal, and we will rest on our briefs as to the alternative grounds that the city raised to affirm dismissal. Now, the district court below dismissed Tejas' causes of action at the 12B6 stage based on the city's argument that res judicata barred its federal claims that were previously raised in a prior lawsuit and were dismissed by the Texas trial court for lack of jurisdiction. We ask that the court reverse this district court's dismissal and remand to the district court because this decision disregards the binding precedent of two high courts. Both parties agree that Texas law governs whether res judicata applies. So to successfully move for res judicata, the city had to meet its burden of pleading and proving that the face of the pleadings and the judicially noticed facts satisfy three elements. First, a prior final judgment on the merits by a court of competent jurisdiction. Second, the identity of the parties. And third, a second action based on the same claims that could have been raised in the first action. I'd like to spend my time discussing primarily the third element because it is most dispositive, and it also addresses the preclusion and finality questions that this court requested supplemental briefing on.
What about the motion for new trial pending below? Does that affect whether the order was final or not?
It affects, so in terms of the motion for new trial that would apply, how that affects the finality, I would say right now, because the trial court maintains plenary power, there is no finality effect of it at this moment. And then once it were to lose that plenary power, it would only be final as to the state takings claim that Tejas asserted in the prior state court lawsuit, because res judicata, a judgment can never be final if a court lacks subject matter jurisdiction, which is what brings me to my point about the third element of res judicata. Tejas filed his lawsuit in November 2018. At that time, Williamson County was still good law and required Texas property owners to first exhaust state administrative remedy procedures. So in Texas, you had to file a lawsuit file a writ of certiorari under Texas Local Government Code Section 211 with a district court within 2 days to seek judicial review of that. And that requirement is both statutory and jurisdictional.
Even before that decision, though, the action could always have been brought in state court, right?
Yes, that's what I was saying, Your Honor. You have to file a writ of certiorari with the state court. So what the writ of certiorari, I believe, is just saying, here's what the zoning board's decision was and some other agenda documents, because you still had to get a final decision from the government agency before you could then go to district court and seek review of that. So if you had to file that writ of certiorari just to obtain judicial review and to vest the district court, the state trial court, with jurisdiction over the state takings claim. And then under Williamson County, you still had to go through and litigate the state takings claim before a federal takings claim would then ripen.
But you could assert the federal takings claim simultaneously in state court, right?
So that's where the issue kind of gets a little bit tricky, because in San Remo Hotel, was based on somewhat on that question whether you could reserve a state takings claim or reserve a federal takings claim and assert a state takings claim at the same time. But even if we were to consider filing at the same time, the Texas Supreme Court has specifically said that a federal claim and state claim can never ripen together at the same time. Otherwise, the two would not get started. And that's because a federal claim only becomes, a federal claim is not ripe until the state court proceedings have been concluded. So you had to first go through and litigate your state claim to a full conclusion, because if you're able to seek compensation, just compensation for your state takings claim, then ultimately your federal takings claim could become moot. Now, turning back to the state court lawsuit with Tejas. Tejas, I guess, as previously mentioned, Tejas filed its lawsuit in November 2018. It was determined that Tejas failed to satisfy that 10-day jurisdictional requirement of filing a writ certiorari to grant the trial court with subject matter jurisdiction over its state takings claim, and so that claim was dismissed for lack of subject matter jurisdiction. At the same time, we did assert a federal takings claim because we weren't sure how to avoid this catch-22 that was talked about in the Nick opinion, and that was also dismissed for lack of subject matter jurisdiction too. And so about a month after those claims were dismissed, the Court of Appeal, or the U.S. Supreme Court decided Nick and abolished the state litigation requirement. So without Nick, our federal takings claim would have never been ripened. And so while the state trial court did not specify the grounds for dismissal, and it's pleaded the jurisdiction, it could not have, as the city argued, dismissed it pursuant to the city's immunity, because having done so would result in the state trial court effectively issuing an advisory opinion on a hypothetical set of facts or speculative claim about how the city's immunity did apply to.
But the state appeals court was very clear that the federal claim failed on the merits also. In other words, it found that the plaintiff had basically purchased the motel, I guess, while the zoning prohibitions were pending and all that sort of thing. It sort of came to it that way. I mean, but that's what the state appeals court held, right?
Yes, that is what it did.
Isn't that a merits determination?
What?
Isn't that a merits determination?
It is not a merits determination, because the state appellate court in Texas, and the Texas Supreme Court was very clear about this in Pearson, which we cite in a brief. An appellate court's jurisdiction to the merits extends no farther than the trial court from which it arises from. So at the time, the trial court did dismiss Tejas' federal claims. It could only dismiss it for ripeness. I think that's indisputable at this point, personally, because it was clear that we didn't file our writ or certiorari within 10 days. We were not able to litigate our state takings claim, and therefore,
But that would mean the state takings claim failed, right? Lack of jurisdiction for the state claim. Would that not give life to the federal claim? In other words, couldn't the state trial court also have addressed the federal claim once it found that the state claim failed?
No, Your Honor. It could only dismiss it for lack of ripeness, because if it were to...
Why is that? Why wouldn't the federal claim then be ripe for review?
Because you were not able to fully litigate a state takings claim, and the Texas Supreme Court has been very clear in saying that a federal claim is not ripe until the state court proceedings have been concluded. So you had to go and seek under Williamson County, you had to go and seek compensation, but without them. And you were not able to do so, your federal claim was dead on arrival because you weren't able to exhaust the administrative procedure processes set forth by the state. So in this case, we weren't able, Tejas didn't file its writ of certiorari with the district court seeking review of the zoning board's decision within 10 days. That was a jurisdictional requirement. By failing to do that, Tejas failed to exhaust its administrative remedies. Prior to Nick, Tejas' federal claim could have never ripened, but after Nick, once the litigation barrier or that administrative barrier was removed, it breathed new life into federal takings claims, restoring them to where the founders initially intended them to be when they enacted the Bill of Rights, according to Chief Justice Roberts. and our claim officially became ripened. In addition to I do want to address very quickly with the brief time that I do have left the district court's reasons for why we failed to prove that, or the first element of res judicata was applied. Turning back to your question, Judge Wilson, the district court necessarily relied on the Court of Appeals opinion addressing the merits of the case. As previously stated, the trial court never was able to address the merits of the case because Tejas' claim was not ripe at that time, and therefore the Court of Appeals was not able to address the merits of Tejas' federal claim. If, for example, the state trial court did address the merits, the only thing that the Court of Appeals could have done and should have done would be to vacate that order for lack of jurisdiction, because it is a prohibited advisory opinion on what the city's immunity is and how it applies to a hypothetical set of facts, because there was never a jurisdiction triggered at the trial court level. And in addition, the Court of Appeals also relied on the city's plea to the jurisdiction, the fact that that was the procedural device being used to dismiss Tejas' claim. Just because a claim is dismissed pursuant to a plea to the jurisdiction does not mean that it's always dismissed for immunity purposes.
Well, but it also doesn't mean it's dismissed for true lack of jurisdiction. In other words, I thought that a plea to the jurisdiction could also be used to challenge the validity of the underlying federal claim.
It can be used on evidentiary grounds too, but it can also be used to challenge whether or not a claim is right or whether or not it has standing.
So a plea to the jurisdiction can go toward jurisdiction, but it can also go more toward the merits in this context, can it not?
No, Your Honor, because the purpose of a plea to the jurisdiction is to defeat a claim without addressing the merits of that claim. It's to divest the subject matter jurisdiction before ever addressing the merits of a claim. And I believe that they talk about that in Bland and Miranda. Miranda versus Texas Wildlife Department versus Miranda, which I believe is cited in both parties' briefing. But also, more importantly, Your Honor, immunity only applies to claims, I want to get this right here. In Zachary Construction Corp. Versus Port of Houston Authority, the Texas Supreme Court said that immunity implicates a court's subject matter jurisdiction over pending claims. So, even though Tejas did assert its federal claim, it was not ripe, and therefore it was not pending before the court. The essence of the ripeness doctrine is to avoid premature adjudication and to hold otherwise would be the essence of an advisory opinion advising what the state law would be on a hypothetical set of facts. So for that reason, Your Honor, even if it was dismissed to a plea to the jurisdiction, it can never reach the merits of the case because Tejas' claim or the immunity, it cannot be dismissed pursuant to immunity because Tejas' claim was not pending before the court. And it's for all these reasons, we request that this court reverse the district court and remand back to the state court proceedings. If there are no other questions, I will come back and talk to you.
Yes, you've saved time for rebuttal. Thank you, Mr. Bobbitt. Mr. Banowsky?
May it please the court. A couple of things are, I think, clear from the record in this case. The first thing that's clear from the record in this case is that Tejas sought to and did litigate the same claims that it seeks to litigate in this case in the state court action.
But it all comes down to whether it's final, right? It has to be final for res judicata to apply.
It has to be final for res judicata. I agree with that. And with respect to the finality question, the case is in an odd posture because Tejas took an interlocutory appeal of that ruling, litigated at the Court of Appeals, sought review from the Texas Supreme Court, which was denied, sought rehearing with the Texas Supreme Court, which was denied, failed to seek review from the United States Supreme Court, at which point in time the appellate court issued its mandate. When the appellate court issued its mandate affirming the dismissal of the claims, the judgment of the appellate court merged with the judgment of the state court, and the mandate dictates that the state district court follow the ruling of the appellate court, as I'm sure this court is well aware. And that includes not just the language in the appellate court judgment, not just the language in the appellate court mandate, but the reasoning in the appellate court's opinion, which means that the state district court, once the case was remanded, and it was only remanded because it was an interlocutory appeal and it had to come back. Once it was remanded, there was nothing left for the state court, the state district court, the trial court to do with respect to Tejas' claims. Now, for reasons that I can't reasonably articulate, once the case was, well, backing up, once the case was appealed under Texas procedural rules, the trial court case was stayed during the pendency of the interlocutory appeal. So what we have is we have the intervener that is sort of mucking up the works, if you will. The intervener's claims could not be addressed at all during the pendency of the state court appeal because of the automatic stay. Once the case was remanded, we filed several motions, including a motion to strike the intervention. We had a hearing on those motions. The state district court took all those motions under advisement and then didn't rule for a year, at which point in time we filed renewed motions. The court wouldn't let us reset the same motion, so we filed renewed motions, including a renewed motion to strike. And we had a second hearing. At the conclusion of the second hearing on the motion to strike the petition and intervention, which was, I think, in the early summer of 2022, the district court granted the motion to strike the petition and intervention on the record. Said submit an order. Well, an order was submitted. An order had actually already been submitted and was thereafter submitted. And for reasons that, again, I can't reasonably explain, the court waited, I think, almost 8 months to sign that order, which this court noticed because the docket's a public record. And so I think it was on December the 19th the court signed that order. I don't believe, and so the case is, and it's a final judgment. It doesn't address Tejas' claims.
You're talking about the December 22?
December 1922.
2022 order.
Yes. It's a final judgment with respect to the intervener's claims because it resolved the intervener's claims. It's my contention that for res judicata purposes, under the restatement, that once the appellate court issued its mandate, that the decision of the appellate court as set forth in its judgment, which was merged with the trial court's judgment, that sufficiently established the finality of that to give it all the preclusive effect that res judicata requires. Because the trial court's not in a position to say, you know what, I've decided I got it wrong the first time when I dealt with Tejas' claims, and so even though you, Court of Appeals, said I got it right, I've decided I got it wrong, and I'm going to undo what we did. The court's not at that liberty. If this court has any concerns about finality, I will go out on a limb and say that, based on my experience with the trial court, I don't think we could even get in front of the trial court on the motion for new trial before the trial court's plenary jurisdiction will expire. I would be shocked if we could get an order entered one way or the other, granting or denying that motion before the trial court's plenary jurisdiction expires.
So all of this, what I hear you saying, although these are not your words, is that at least as a practical matter, it's final.
Well, as a practical matter, it's final, and as a legal indisputable matter, if this court doesn't issue an order doesn't issue its opinion in the next 55 days, then it will be clear that the trial court will have lost all of its jurisdiction, and any way you slice it, it will be final. And the important point, I think, with respect to all the issues of Nix and not standing, but rightness, the question here is, so the appellant cites Eagle Oil for the proposition that res judicata doesn't attach to a claim that's not ripe at the time that the claim is filed. And also cites a federal case called Bonin versus Sabine River Authority for the same proposition. I will point out in Bonin, they do address the question about whether or not the trial court had subject matter jurisdiction to dismiss the claims on a plea to the jurisdiction, and that dismissing the claims like this, it was a takings case, dismissing claims like this on a plea to the jurisdiction constitutes, as all of the case law says, a final judgment on the merits of those claims. In both of those cases, the claims that were being sought to be litigated in the second action were claims that were not litigated in the first action. So the question was, under the transactional approach to res judicata, do these claims that were not litigated come within the realm that we're going to apply preclusive effect nevertheless? But this court should recognize that res judicata applies. That third element of res judicata applies in two different scenarios. With respect to claims that should have been litigated, and that's the whole transactional approach, or with respect to claims that were actually litigated. I don't think that there's any question, I don't think that this court could see that there's any question that if a plaintiff had two claims, let's say two breach of contract claims, one of them ripe at the time they filed the suit, one of them not yet ripe because there needs to be some passage of time or some subsequent event, and the plaintiff brings the first breach of contract case, and then during the course of the litigation, the second claim ripens. We're not here to answer the question, what happens vis-a-vis res judicata to the second claim if the plaintiff never brings it in that first lawsuit. We're here to answer the question, what happens if in that first lawsuit, the plaintiff then, after the claim ripens, brings the claim, litigates the claim to conclusion, and loses? Can the plaintiff then file a second lawsuit and say, yes, I know that I filed that lawsuit and I brought that claim and I lost, but at the time that I filed the lawsuit, the claim wasn't ripe. Therefore, I get to have a second bite at the apple. And the answer to that question is clearly no. And the result is easy to see in both Eagle Oil, which was that case, the case I just described. There's a first claim and then a second claim that requires some activity on the defendant. It's a contract claim that requires some activity on the defendant to actually accrue. And the plaintiff never brought the second claim. It accrued at some point in time during the litigation, but it was never brought, and it hadn't accrued at the time that the case was filed, so it accrued later. So if you read Eagle Oil to say anything, it says that the plaintiff is not under an obligation under res judicata to add to a pending lawsuit claims that accrue after the case is filed. But what do you do in a case where the plaintiff elects to bring those claims? And the case law is clear, Texas law is clear, and federal law is clear, that the plaintiff in this case, Tejas, could bring its state law claims and its federal law claims
At the same time,
at the same time, but there's a
currently.
concurrently.
So that's my question, I guess. When the state claim fails because it wasn't perfected within the 10 days, they didn't, get the procedures right and assert it timely, no jurisdiction. Is that when the federal claim ripened?
Well, I'm probably not an expert on the ripening of federal takings claims, except I will say this. There are facial attacks to these city ordinances which don't have exhaustion requirements at all that were asserted in the state court case and in the federal court case. And those claims were also addressed by the state appellate court, and the state resolved them against the plaintiff. A very narrow band of the claims brought by the plaintiff had exhaustion requirements under Williamson County at the time that they filed. During the pendency of the lawsuit, and I will tell you though, under the Williamson County law, both the Texas Supreme Court and the United States Supreme Court says a plaintiff can bring the state claims and the federal claims that are subject to an exhaustion requirement simultaneously in the same action, alternatively. And yes, the answer is if you're unsuccessful on the state claim, then you can still succeed on the federal claim.
You can succeed before the state court.
Before the state court.
But if your state claim dies because of a jurisdictional defect, it was not timely, counsel opposite indicates that they're in a catch-22, that the federal claim can never spring to life because they never exhausted the state claim. Is that so?
Well, it's not so for a couple of reasons. One is because not all of their claims were subject to exhaustion requirements to begin with, even under Williamson County.
But the takings claim, so it fails because of jurisdictional issues. Does that count as exhaustion?
I don't know if it does or not. What I do know is in this case, it was after the judge, admittedly, it was after the trial court judge signed the order on the plea of jurisdiction. It wasn't very long after, it was a few weeks after. And it was before the plaintiffs filed their appellate brief in the appellate court, Nix was decided. And so it was clear before any briefing was even done in the state court appeal, it was clear that Nix was the law and there was no exhaustion requirement. Now, the law in Texas is, and I assume it's the law in this circuit as well, is that the Court of Appeals has to apply the law to the case that exists at the time that the Court of Appeals is hearing the case. And Nix was the law. And the plaintiff argued to the Court of Appeals, the State Court of Appeals, that there was no exhaustion requirement under Nix. And we know that there was no exhaustion requirement under Nix. And then the state appellate court resolved the claims, and it's clear that the state appellate court resolved the claims on the merits. And here's what I would like to point out with respect to that. What the state appellate court says is, although a city is not immune from federal constitutional claims, a trial court may grant a plea to the jurisdiction if a constitutional claim is not viable. And then the court goes into a several-page analysis of the viability on the merits of the appellant's federal constitutional claims. And then, at the end, the court says that Tejas' federal constitutional claims fail because it has no vested property interest in maintaining a nonconforming use, and because it has no reasonable investment-backed expectations in continuing that use. The trial court did not err in granting the plea of the jurisdiction, and we overrule Tejas' first issue. And then in a footnote, and I think this is important, and it's kind of why we're here. In a footnote, footnote 5, the court says, to the extent Tejas asserted other federal constitutional claims in its third amendment petition and supplement, it has failed to sufficiently identify those claims on appeal or cite appropriate record evidence and authorities differentiating them from the other claims to demonstrate they were not also subject to dismissal. Thus, Tejas has preserved nothing for our review that we have not addressed elsewhere in this opinion. And so the point is that litigated this case to completion in the state court. I think for res judicata purposes, because of the peculiar circumstances related to, it's an interlocutory appeal, but there's a mandate, and all of Tejas's claims were resolved by the trial court's order dismissing the case and the mandate affirming that order, that I think that the case is sufficiently, that the decision is sufficiently final for preclusive effect and has been since the appellate court issued its mandate. If this court has any concerns about the finality issue, that's easily resolved by not issuing an opinion before April the 5th. That's all I have. Any questions?
All right, thank you, Mr. Banowsky. Mr. Bobbitt? Save time for rebuttal.
Thank you. So first thing I want to address is that in regards to the mandate argument, merging with the final trial court or the interlocutory judgment, the city never raised that in the trial court, and we would argue that has been waived or forfeited.
And so what do you do with, a separate question, but Mr. Banowsky's suggestion that things will be different if we wait until after April 5th to issue an opinion here?
Nothing will be different, Your Honor, because a opinion or an order rendered without subject matter jurisdiction is void. Full stop. A court lacks the jurisdictional authority to do so. That violates the prohibition against advisory opinions. My friend on the other side brought up Eagle Oil and Gas, and there the Texas Supreme Court clarified what the preclusion law is in Texas by stating a black letter rule of law. Res judicata cannot apply to a claim that was not ripe at the time the lawsuit was filed. And in the Bonin case, both the magistrate judge and the district court judge go through and explain that this proposition does not stand for, well, a claim can ripen, res judicata doesn't apply if the claim ripens after it's filed, while it's pending. It has to be at the time the claim is filed, or the first lawsuit is filed, that the claim is ripe for res judicata to apply. And it's unmistakably clear that based on Texas Supreme Court precedent and U.S. Supreme Court precedent, Tejas's federal takings claims were not ripe at the time the state lawsuit was filed, because Tejas had to first assert or exhaust the state litigation requirement. So even if it brought its claim simultaneously, it didn't matter, because that federal claim still had to wait for the state claim to be ruled on and denied and to exhaust the administrative procedures. And then, in addition, with the plea to the jurisdiction, all the cases that the city cites for support of immunity being a final judgment on the merits, those cases all expressly state that the claims were dismissed pursuant to a plea to the jurisdiction based on a governmental unit's immunity. The order granting the plea to the jurisdiction in those cases specifically states that they were dismissed pursuant to immunity. Our order here in the state court lawsuit on record page 87, I do believe, does not state the grounds for dismissal. All it states is that it was dismissed for lack of subject matter jurisdiction, and because there are alternative grounds for the reasons that the state trial court could have dismissed the Tejas's federal claims, ripeness being the one that we are arguing, the city argues immunity. The city had to meet its burden, or had a burden of proving that immunity was the sole basis for the grounds that the trial court in the state court proceedings could have dismissed Tejas's federal takings claims, because under Texas law, and we talked about this in our reply brief a little bit more, and our letter brief, with the Johnson-Higgins case, the Texas Supreme Court says there can be no preclusion effect for, there can be no preclusion where there are alternative grounds for a holding, which are both equally plausible. We argue that under Williamson County, the time that it was, the state court dismissed our federal takings claims. Our federal claims were not ripe. The city argues for immunity. Both are equally possible. Next, I want to readdress in the time I do have left. The city fails to prove that the Dallas Court of Appeals that issued the opinion in the interlocutory appeal had the jurisdiction needed to reach the merits of Tejas' federal takings claim. A state appellate court lacks jurisdiction over the merits if a state trial court lacks jurisdiction over the merits, and a state with subject matter jurisdiction being a threshold issue, the state trial court was duty-bound to determine its own jurisdiction before reaching the separate issue of whether or not the city's immunity defeated or divested the state trial court of that jurisdiction. And so, therefore, the Court of Appeals lack jurisdiction, and we respectfully ask to reverse and remand. Thank you.
Thank you, Mr. Bobbitt. Your case is under submission.